Good morning, everyone, and I hereby call the Interim Joint Committee on the Judiciary to order. And Robert, would you please call the roll?
Senator Carroll.
Here.
Senator Deneen. Here. Senator Neal. Senator Nemes.
Present.
Senator Reed. Senator Stivers. Senator Thomas. Here. Senator Wheeler. Representative Banta.
Present.
Representative Bauman.
Present.
Representative Blanton. Representative Burke.
Here.
Representative Decker.
Present.
Representative Dietz.
Here.
Representative Flannery.
Here.
Representative Griffey.
Here.
Representative Kulkarni. Representative Chris Lewis.
Here.
Representative Derek Lewis. Representative Maddox.
Here.
Representative Marzian.
Here.
Representative Moser. Representative Nemes.
Here.
Representative Petrie.
Here.
Representative Roberts.
Here.
Representative Stevenson. Representative Whitaker. Representative Williams. Representative Wilson.
Here.
Co-Chair Storm.
Here.
Co-Chair Elliott.
I'm here. And so there is a quorum. Is there a motion to approve the minutes of the August 29th? There's a motion. There's a second. All those in favor, please say aye. Aye. Those opposed, no, and the minutes are approved. The first item on the agenda is an act relating to machine gun conversion devices, and we have the House Majority Whip with us this morning, Representative Nemes, to present, and I know he has some guests who should introduce themselves for the record, and then we can proceed.
Yes, Your
Good
Honor.
morning.
Your Honor, I've been in court yesterday morning and the day before. Thank you, Mr. Chairman. My name is Jason Nemes. I'm the state representative. I have Jefferson, Oldham, and Shelby counties.
Yes, sir. Paul Humphrey. I'm the chief of local commercial police.
Drew Fox. I'm a lieutenant with LMPD over our gang enforcement unit and our firearms investigation unit.
Mr. Chairman, we do have two persons with us on Zoom from Alabama legislators, if they could introduce themselves.
Good morning. I'm Philip Ensler, State Representative, District 74 in Montgomery, Alabama.
When they testify, maybe the other one can get off mute and introduce himself. Okay. So I'm going to be quick, Mr.
Right, and I want, before you start, I wanted
Yes,
to say that I'm going to impose, we have several bills here, so I'm going to impose a 10-minute timeline or restriction on the presenter, and then the committee, if we need more time to ask questions, that's going to be fine, but I want to make sure that the committee has time to ask questions, so.
Okay, well,
I'm not taking any of your time, so.
I'll be 30 seconds, Mr. Chairman. Thank you.
Okay.
This was brought to me by my mayor and our police chief who's here, and then also some citizens. You have a letter from Glock in the packet which supports the bill. What this does is it says that it mirrors federal law, which already says that these devices are unlawful, and it makes it unlawful in Kentucky as well. Why is that important? Because right now we're not allowed to enforce federal law, obviously, with the state. So we need a state law. There are 26 states that have done this. And just so you know what an auto series is, it makes a semi-automatic where you pull the weapon, bang, 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 into an automatic weapon where it goes off until you're out of ammunition or you remove your finger. This does not, last thing I'll say, this does not, one thing I think is important as we're finding out what gun laws we want to pass, it does not make anything unlawful that is currently lawful. I cannot possess an auto sear today. It violates federal law. That does not change. It will violate state law as well, but it's already unlawful. It does not take away anybody's right that they currently have. With that, ask Chief Humphrey.
Yes, sir. Thank you. And to take it a bit further, to give you some perspective on what we are talking about Glock switches that are aftermarket manufactured, often now made on 3D printers. They're devices less than the size of a quarter that just get attached to the back of a pistol. And that is all we're talking about today is those particular devices. They can be held in a pocket, on a chain around somebody's neck, and then popped on the back of the gun very, very quickly. And we're not talking about something that helps with accuracy, that helps with self-defense, that helps with home defense. We're talking about something that actually makes the weapon far less accurate and far more dangerous to everyone around. And this is a problem that has increased steadily over the past couple of years. And bear with me if I can give you a couple of statistics really quickly. In 2023, we seized LMPD 26. In Jefferson County alone, there were 31, and 13 were seized in the rest of the state. 2024, that number jumped drastically up to a total of 80 within Jefferson County, 58 by LMPD, and 18 out in the rest of the state. And then when you're looking at year to date, LMPD has seized 37 so far year to date. So we've seen an increase. The other disturbing thing that we've seen as a trend along with this is the age of possession. And the age of possession has dropped from 29 years in 2023 to 26 years in 2024 and is now at just 21 years of age for the average age of possession. And understand what we're talking about here, we have no ability to enforce this. So if we get somebody in the process of a separate crime that is not necessarily involving the gun, but they're in possession of this, there is nothing we can do other than give that back to them. The only hope that we have of any type of enforcement of this type of weapon is to be dependent on the federal government, particularly the ATF, to not only pick up the case, but go forward with the prosecution. This type of legislation gives us primary ability as an officer to encounter people like this and be able to take enforcement action, serious enforcement action, because we understand the impact of the violent crimes that are going on our streets and in our neighborhoods. And this is exacerbated greatly by this problem. And what it does is it turns the ability for us, the local police officer, the local prosecutors, to be able to take some kind of action on these that we currently cannot take.
Thank you, Mr. Chairman. Mr. Ensler to begin, and I think the other legislator was kicked off, and I think he's coming back on. Okay, Mr. Ensler, Representative Ensler.
Great. Thank you all. And I'll just briefly share why there was a need in Alabama and how we passed it. Very similar to what Chief said. In Alabama, we saw a proliferation of these devices. And I increasingly heard from local police, from sheriffs, from our district attorneys that they were finding more and more of these devices, but the best they can do is turn it over to the feds, turn it over to ATF. And the feds then were sharing that they were increasingly stretched in dealing with greater and greater caseload. There were also some very tragic, unfortunate, high-profile shootings in different parts of the state involving these Glock switches or conversion devices. On a more personal level, and certainly in my district, I know how traumatized, how hurt families were, loved ones, young people were from losing people that they knew in these really horrible mass shootings. So there was increasingly an understanding that there was a need for a state-level ban. I worked very closely with all the different law enforcement groups that I mentioned, and then with my colleague, Representative Betzel, and other leadership and Republican members to have a very strong bipartisan effort. We worked very closely to make sure that our bill closely tracked federal law to the point that was made. One of the biggest challenges or questions we overcame was why is there a need for this, and the need being to empower local law enforcement and state law enforcement and district attorneys. And then also, it's a way to, it's not going to solve or stop every situation, but it can prevent some of them. We did fortunately pass the bill with a bipartisan effort. The governor signed it into law to go into effect immediately. And we've seen already the benefits of it. Hundreds of these devices have been taken off the streets. Of course, we can't count every time a life has been saved or a crime has been prevented, but just knowing that hundreds of these have been confiscated on the state level and local level really makes a tremendous difference. And the last thing I'll say is from a standpoint of just educating members, we brought representatives and state senators out to shooting ranges. They saw how incredibly dangerous these are. As was stated in the beginning, this is not used for self-defense or recreational purposes. Once one of these are fired, the bullets spray in every which direction. So at the end of the day, it really is a public safety matter. And we came together in Alabama, Democrats and Republicans, to pass this and enhance community safety. And with that, I'll turn it back over. And if my colleague, Representative Betzel, has anything to add in whenever it's the appropriate time.
Good morning. If the committee is ready, if they can hear me okay, apologize. I had to make a swap from my desktop here to my phone. Mr. Chair, are you able to hear me okay?
I am, and if you would just introduce yourself, and then you can go ahead.
Sure. My name is Russell Bedsole, and I serve Alabama House District 49, situated just south of city of Birmingham. My district is some of the suburban areas of our largest, or now second largest city in our state. So it's a pleasure to be with you today in this committee and just echo some of the things that Representative Ensler had to say. I'll also speak to you not as only as a representative, but as a member of law enforcement, which I'm still active. 27 years of serving Shelby County, Alabama, and just proud to be a member of this legislative body that also represents the men and women of law enforcement. So a little bit on how Alabama made this a bipartisan issue. You know, as policymakers, we certainly owe it to our constituents to engage subject matter experts every time that we express or have an issue such as this. This doesn't mean that we have to agree with them every single time, but certainly we need to hear them out and to guide our own decision making in the legislative process. And I think we're hearing some of that from the chief today as he spoke. And that's exactly how our machine gun conversion device bill, Glock switch bill, came to be and eventually succeeded in Alabama. We're a state that backs our law enforcement fully, and when law enforcement professionals came together communicating that the need to make their community safer, we had to hear them out, and we did. I think in the process, my Republican colleagues, and even to me as an extent, got an idea that what fact and what is fiction with these devices. Many came to the realization that voting to ban these devices at the state level really has nothing at all to do with the Second Amendment. When my colleagues realized this is simply mirroring state and federal state law with federal, not creating any new gun laws for citizens to be subject to, I think they began to realize the importance of the legislation. The bottom line is this: no way does this legislation impact Second Amendment. What it does is allows our state and local prosecutors to enforce the law without having to rely on our federal counterparts. Now, as an aside from my professional career, speaking to those who specialize in tactical operations, you know, a fully automatic device is not the preferred weapon of our most skilled tacticians. There is not a level of accuracy to do their job, and so these Glock devices certainly fall into that category, and then to an extreme to some degree. I cannot speak for how widespread this issue is in your state, but happy to discuss the impact in my own. So I'll give you a couple examples if you don't mind. Montgomery, Alabama, our capital city, has a task force comprised of local, state, and federal law enforcement working since June of 2024, so roughly about 16 months. In that time, and mind you, this is the city of Montgomery only, they have confiscated 171 of these devices. In April of this year, the task force executed a search warrant and found over 50 of these devices in one location. Birmingham, Alabama, second largest city, which I told you I'm sitting in a suburb. Police believe the shooter of a Hush nightclub shooting used a conversion kit in the attack outside of a lounge. The incident killed 4 and injured 17. Tuskegee University, small community university. One person was killed, 16 others injured with the use of a conversion kit. And then something I'd like to point out for any of the members there that sit maybe in a smaller community and wonder why that this affects you. Dadeville, Alabama, population of about 3,000 total residents, just 3,000. 16-year-old birthday party. The shooter was believed to use a Glock conversion kit there, killing 4 and I believe injuring as many as 30. So I think this is an issue that affects not only the large big cities in our state specifically, and I'm sure it would be similar to yours, but also some of the smaller communities. So members of the committee, I appreciate this opportunity to speak to you today and address you about what we saw in Alabama and what we're continuing to see today. So thank you for your time.
Mr. Chairman, I want to thank Representative Ensler and Bedsole for coming here today from Alabama. I appreciate that very much. We're ready for any questions that you may have.
Thank you. And I was recently in Alabama and had a very nice trip. So thank you for being with us. We do have some questions. I have a couple. Since I have the gavel, I guess I get to go first. The penalty here is a Class C felony. Is that in line with the federal statute in terms of the way we're going to penalize this if this were to be successful?
I think it is. The C statute is 5 to 10.
Okay. And I read that, at least in the letter from Glock, that if I can say this word, proliferation from China is primarily the source of these of these devices. Is that true from the chief's perspective?
So it's my understanding that not only they're coming from overseas, but this is something you can order easily off the internet from kids making them in their basement on a 3D printer. They're no longer difficult to make. They used to be made out of metal, and now they're made out of plastic very easily.
Okay. Thank you. Representative Roberts.
Thank you, Mr. Chairman, and Representative Nemes, thank you for the discussion we've had before this matter, and thank you to all who presented on this. I just have a couple of practical questions and then one that's more on the constitutional side of matters. So the first one, when we're talking about the fact that LMPD is currently seizing these and seems to be seizing several of these and turning it over to the feds, I'm just wondering why we need a state law ban on something that's already illegal at the federal level, especially when the federal government doesn't offer parole for these matters.
Yes, sir. Thank you for the question, because I think that's a very important distinction. If this law were to pass, we would actually see our numbers of seizures go up probably drastically, because we have no ability to seize that weapon or charge anyone criminally for the possession of that or the possession of that on a weapon. So these would be seizures where we are arresting them either for a gun or violent crime or for something else where we have the ability to take that gun, and then those are the ones that are picked up and prosecuted by the feds. This does not include numbers that were either released back to the person or the feds did not pick up.
And on that end, what are the instances where a firearm that has a machine gun conversion device on it are being returned to the owner? What are the circumstances that result in that? And is there a federal or state law that prohibits y'all from making arrests on this issue?
So the thing that prohibits us from making arrests on the issue is there is no law that makes it illegal. So just like any other gun in the state of Kentucky, you can possess it. And we have no primary authority when it comes to tax stamps and FFAs to enforce any of that. And I guess there's some technicalities about who can even ask for a tax stamp, being just the ATF. That being said, we have had issues where people have been in possession of these, and we know they're in possession of it, and there is nothing we can do about it. We recently took one off of a person who was fleeing from us. A passenger in the vehicle was charged with sodomy first. They ran over an officer, broke her ankle. He fled with the gun in his hand. He was not a convicted felon. So other than the charges that he's getting, if the feds don't pick that up and he ultimately does not become guilty of a felony, he will get that gun back.
Okay. And second, on the practical side of it, just what is considered to be a conversion device? Because I'm looking at subsection 2. I mean, it states any part or combination of parts. And my concern with it, so the Glock switch itself is considered a machine gun under current law. Would a 3D printer be considered a conversion device if it's being used to manufacture one of these? Would a nail file or any other device that can be turned into, say, an auto sear for an AR, would those be considered machine guns or conversion devices under this law?
That's certainly not our intent. It wouldn't be a combination of parts. It would create the part, but it's not a part in and of itself. So we don't intend to include the printer as part of the device. It's the portion of the device that goes onto the back of the Glock or on the back of the semi-automatic, which effectively stops the striker from continuing to strike.
Okay. I do have concerns about the breadth of the bill text. I understand that might not be your intent, but I do think bill text is king. But finally, on a constitutional end of this, because right now prohibitions on machine guns are being litigated in federal courts right now, whether it's constitutional, whether the NFA is constitutional. And we saw dismissal in Kansas. That's currently been reversed by the 10th Circuit, but it seems that it's a disputed issue. And I'm concerned that we might be opening ourselves to litigation. So I just have to ask, under the current federal standard, is there a historical analog from the time of the founding for this prohibition that justifies this state-level prohibition that's being proposed here?
Well, obviously, if those cases are successful in challenging the federal law, then ours would not be enforceable either. But they've not been knocked down. They've been on the books for some time now. I think they're lawful. I think the question is whether or not these types of devices were allowed at the founding, and obviously this is It allows for a rapid rate of fire, and it's unlawful federally, as I think the courts will hold that that's a constitutional restriction, and I think we should fall in line. If the courts disagree, then obviously that our law will not be enforceable.
Just a very brief, just closing remark. Clarence Thomas described the Second Amendment as what the courts have considered to be a second-class right, and I think that is the case here in Kentucky right now. I think this is already illegal at the federal level. Further, I think that we have fundamentally failed to protect the Second Amendment rights of Kentuckians, whether that be through not letting all law-abiding adults carry for the purposes of self-defense, whether that be having victim disarmament zones in Kentucky well beyond what federal law currently requires. I think we've sorely missed out on opportunities to ensure that the Second Amendment is not a second-class right. I think our energy is better spent actually expanding this right to self-defense rather than imposing further restrictions that are already illegal at the federal level. Thank you for your presentation.
Mr. Chairman, I want to Representative Roberts is someone with a great integrity, and he's in this position he's had, and I respect you for that. I would disagree that Kentucky hasn't protected the Second Amendment right. I bought 2 guns within the last 60 days. They took me less than 10 minutes to buy, and I've built an AR within the last 6 months. I'm a Kentucky citizen. There was no prohibitions for me doing that. They were easy to do. I don't think there are restrictions in place that are a problem. When I look at gun laws, I think we should do effectively 4 things. Keep them from the mentally ill and help identify who the mentally ill are and give them treatment. Number 2, we need to keep guns from people who shouldn't have them, felons, and people who have had a finding of a domestic violence order, things of that nature. Number 3, we need to strongly enforce the law that we have currently on the books with background checks and so forth. I know you and I disagree on whether we have to have background checks and those kinds of things, but we have those kinds of laws. We need to strongly enforce those laws. And then number 4, when somebody uses a firearm in the commission of a crime, we need to take that very seriously. And you and I both voted for the Safer Kentucky Act a couple of years ago. You weren't here. We voted for the Safer Kentucky Act a couple of years ago, which we are doing that. You have to serve 85% of your term of your sentence now if you commit a crime with a firearm. You can't get out of you can't be probated. So we're taking that very seriously. So with those 4, we need to do those 4 things, all while protecting the law-abiding gun owner. This doesn't change that at all. It's illegal to have this device today. It'll be just as illegal, no more so, once we pass this, if we pass this bill. Thank you, Mr. Chairman.
Thank you.
Thank you, Representative Roberts, and I echo what the majority whip said. I will not, and have tremendous respect for Representative Roberts and his position. I would note that Justice Scalia said in the Heller versus District of Columbia case from 2008 that the Second Amendment right is not unlimited, and it does not extend to carrying any weapon anywhere for any purpose. So we're all very strong proponents of our Second Amendment, but we do recognize that there are some limitations. Representative Blanton.
Thank you, Mr. Chairman. Thank you, gentlemen, for being here and your presentation. I doubt there's anybody sitting on this committee or in this room who's got any more firearms or ammunition than I do. I believe in our Second Amendment, totally. Chief, my question is this. The ATF can prosecute these cases. How many or what percentage of these cases are they actually prosecuting for you in Louisville?
For that, I'll turn this over to Lieutenant Fox, who has a wealth of experience in dealing with the ATF.
So on a percentage basis, I can't give you a percent today. Unfortunately, I can get that number and get back to you. This device alone is usually not something that they're going after, as well as some of the lower level offenses where we've got folks with stolen firearms or, frankly, even some of the lower level of trafficking in firearms because of the workload that's been put on the ATF. They have a very significant caseload dealing with some of the worst folks who would categorize as an armed career criminal, and that's where the majority of their efforts are spent because of their limited resources.
Thank you, Lieutenant. Follow up, Mr. Chairman?
Yes, sir.
Thank you. So I'm totally supportive, and I would remind the committee that if we pass as a state law, this does not prevent the federal law enforcement from coming in and also taking this case and moving forward with it. You guys in law enforcement have to have some type of protection. These type of things are things that people are using more for an offensive stance than a defensive stance. I would remind the committee, if you're old enough to remember, it wasn't too many years ago out in California, there was a group of bank robbers that went in fully armored, full automatic weapons. Law enforcement did not have the weaponry to combat those people. They were literally going to gun stores trying to get weapons to address the threat. Most of our law enforcement, I know I've been retired from it for a few years now, but the state police doesn't carry fully automatic weapons unless it's our special response team, and I would assume that that's probably true with the Louisville officers as well. Your officers are not equipped with fully automatic weapons that are the street cops. And if they come up against one of these individuals, they're going to be outgunned. And not only does it place the public in danger, but it places our law enforcement members in danger. I didn't even realize till today that these type of things were now in production. Doesn't surprise me. And we have to do everything we can to combat that. So I fully support you all. I support this piece of legislation. I think it's good common sense. And I do not think that any stretch of the imagination that we can consider this a violation of Second Amendment rights at all. This is just simple common sense legislation. Thank you, Mr. Chairman.
Sir, may I respond to your comment, sir?
Yes, go ahead.
Okay, and just to give some perspective, no, we don't carry full auto guns as part of the police department, and I spent almost a decade on the SWAT team, and in that time I had both an MP5 that was full auto and suppressed and an M4 that was full auto and suppressed. And over the course of my 10 years across the country, you saw every SWAT team, every major SWAT team get away from full auto because nobody ever used it because of its inaccuracy. It is inherently an offensive tool that is not meant to be accurate. And so law enforcement, for the most part, has gotten away from it. And that's part of what the issue with this is. I've never shot a full auto pistol. I have no desire to because you can't control where it goes. And that is part of the issue with this, is that people pull the trigger once and they might know where that first round is going, and they have no clue where every round after that goes.
I would say on a double tap, it's hard to even get your second round in, let alone a fully auto. And I have shot fully auto, and you're correct, Chief. Thank you.
Representative Flannery.
Thank you, Mr. Chairman. I have two questions, please.
That's fine.
I just want to be sure I understand what these switches do. I think I understand, but I want to be sure that we're on the same page. So simply, a switch converts a semi-automatic handgun to an automatic handgun. Is that correct?
Yes, sir.
And so that would make them, I guess, more what we would call a machine gun, which I think violates the National Firearms Act of 1934. Is that correct?
Yes, sir.
Okay. I think I heard you say this, but is the rationale on why we need this, it's not because the feds are not picking the cases up, but because it would enable law enforcement and prosecutors to be more involved when it's a possession-only type situation. So you could seize them if they are used in commission of a crime, but if you happen to run across an instance where it's clearly someone's in possession of a gun that has a switch device on it, but has not used it in the commission of a crime, you would be unable to charge that person. Are we on the same page as to why you're asking for this?
Yes, sir. And just to enhance that a little bit, and it also goes to what Lieutenant Fox was talking about, is that even when we have people in the commission of a crime, that does not mean that they will receive any enhanced penalties or any punishment for the usage of that Glock switch in that crime if the feds don't pick it up. There is no ability for the state prosecutor to do anything with that.
Okay, just one follow-up.
Please go ahead.
Has there been an overload of cases where the feds are not picking these cases up? I heard maybe a little bit of chatter on what was happening in Alabama, but from a Kentucky perspective, is this such volume that they're just unable to prosecute because of the sheer volume of these instances?
Simply put, yes, sir. That's there is a sheer volume of violent crime right now. Even though we're trending downwards, we're still having some significant issues, and some of you guys are seeing that even outside of Louisville. You know, the legislators in the forest rural parts of the state are seeing folks who are coming from our city, going to your small towns and stealing guns and shooting at people when they confront them. We've had cases and instances of that. These cases are all very important, but in the overall picture, law enforcement has been down over the years. The feds are no different, and so the sheer volume at the ATF level has limited their resources. This is something that we don't have the best ability to be able to prosecute some of the violent offenders who are on our streets that are perpetuating some of these crimes now.
Thank you all.
Senator Carroll.
Thank you, Mr. Chairman, and gentlemen, thank you for being here today. And I too support a common sense approach to the Second Amendment that best protects our public and our law enforcement officers. And it's crucial that we take every opportunity to make the streets safer for both. As a retired police officer, couple quick questions. Chief, you mentioned that these devices can be purchased online, and I'm assuming it would be. You can't get it through Amazon or something like that with the legitimate sources due to the federal law. Is that correct?
That's the way it should be. I'm not sure that's the way it always works.
Okay. So you could feasibly buy one through Amazon, and that would not be a federal violation by Amazon?
I'll let Lieutenant Fox handle that part.
So I think from the legal aspect, Representative Nemes being an attorney, will be able to answer that a little bit better. From the practical aspect, what we've seen, we are seeing an influx, not necessarily from Amazon, but from other sites that I won't mention here that are not on the up and up. And we're seeing an influx of devices that are purchased illegally. They're imported. Customs and Border Protection is not always seizing those because they're not always seeing them, just like illegal narcotics. But we have had several instances where they are being seized, and not only are they being shipped here, but we're also seeing issues where they're being manufactured here.
Senator, I'll get back to you on the answer, but I believe the answer is it certainly would be illegal for the manufacturer, for the retailer, and for the purchaser. But I think the carrier has immunity. I will double check that and get it to the whole committee, but I believe the carrier would have immunity.
Okay, Mr. Chairman, if I might, one more.
Yes, go ahead.
In Section 3B, where it talks about where I guess these devices can be registered, and help me understand that. So if you were to illegally purchase one of these, but then you could register it and it would be legal at that point, or help me understand that section.
So you can get a automatic license, but you have to get that in advance. I don't think you could buy this and then make that which is illegal legal.
Okay.
But it takes a special license to get an automatic weapon, but you could get that today.
And then
not today, over time.
And then the purchase and possession of this device would be
That's right.
legal at that point?
Provided that it's legally purchased, yes.
Okay.
So it would. So what we're saying is, what we're trying to say here is, if you have a license to have an automatic weapon, we're not making that illegal. If it's already legal federally, it's going to be legal here as well.
And just a point of clarification, that tax stamp applies to a particular weapon, not to the person.
Right.
Oh, okay. All right. Thank you very, very much. Thank you, Mr. Chairman.
Thank you, Senator Wheeler.
Thank you, Mr. Chairman. A couple of brief questions, if I may. This is to follow up a little bit on some of Representative Flannery's questions. I mean, is there anything... is it the department's policy right now to refer every one of the persons encountered with this type of device to the U.S. Attorney's Office for prosecution?
So I'll let Lieutenant Fox handle that, but our firearms intelligence unit reviews every single firearms case that we take in, and they help work with the prosecutors to determine how that's going to go forth.
So currently we review every firearms case that every time someone's arrested in Jefferson County with a gun, it goes through on a report. We look at those instances, look at instances where a machine gun conversion device was recovered, and that's another means of using the limited resources that we have to go after the most violent is effectively what we're doing there.
and again, I'm not trying to. I don't know that completely answers my question. As do you refer? For example, the guy you said that was accused of sodomy and was running away, and you found him with this device. Was he referred to the U.S. Attorney's Office for prosecution for having this device?
Yes, sir. That would be a case that would go through. It would be discussed with the U.S. Attorney's Office as well.
What if it was just a marijuana dealer on the corner of the street and you found him with this device? Would you refer him to the U.S. Attorney's Office?
They would see that on this screener report that we've got, and they may or may not elect to take that case up.
Okay, but you would refer it whether or not they agreed to take it up.
If we had cause to seize that firearm and it was an arrest, they would see that and it would screen.
That was what I was asking. So
yes,
anytime
sir.
you encounter one of these devices, you refer it to the feds, and then the feds decide whether or not they want to prosecute the possession of the device.
Yes, sir.
And just further on that, not every time we see one, it's every time we seize one.
Why don't you refer?
Because
every time you see one, I mean,
because if you're legally in possession of the firearm, otherwise, we don't have cause to take that firearm from you just because it has a Glock switch on it.
Yeah, okay, I get that, but I mean, obviously, if you're encountering them, well, if you see them shoot the weapon and it shoots off, an automatic spray of bullets, you would probably have probable cause to see whether that person had an appropriate license to have that device, and if he doesn't and he has this device in possession, why would you not refer this to?
Yes, sir, and that would, and just so and just to give you a kind of a more realistic example, if you had a bench warrant for something, some misdemeanor that you didn't appear in court on, and I arrest you for that, and you're otherwise legally in possession of that gun, they will never see that.
Well, why not? I mean, you found them in connection with an illegal device.
Well, they're not going to prosecute that. They will not pick.
Are you
that
sure
case
about
up.
that? I mean,
they will not
if
pick.
You don't
that case
refer
up.
it. Okay,
sir. Based on our practice, we've not seen them prosecuting those lower level offenders that are in possession of those. That's practically speaking, we've not seen that.
Okay, and all right. So I guess my concern is, I mean, I'm not trying to point fingers here, but, for example, sometimes on immigration issues, we've seen a lack of cooperation on local authorities' parts in the past enforcing those types of federal laws. I wanted to make sure that there was no policy on the departments. And I know that's since been fixed, as part of an agreement with the administration. I just wanted to make sure that there wasn't a similar pattern going on where the LMPD or whomever the locality is was picking and choosing which one of these cases to refer to the federal government for prosecution.
No, sir. I have no problem with seeking the highest level of prosecution possible for violent gun crimes.
Mr. Chairman, I need to take 10 seconds if I might.
Yes, sir.
So I just want to be clear. There's never, ever been a policy for my city to not engage and not cooperate with immigration. So my city got a letter from the first Trump administration saying we were not a sanctuary city and we were in compliance with all rules, all laws. And so recently, 4 jurisdictions across the Commonwealth, including mine, were put on a list. We immediately contacted them and said, what's going on here? They said, here's what needs to change. We immediately made that change. There's never been an effort not to comply. We are not a sanctuary city. We've never been a sanctuary city. We don't intend to become a sanctuary city. Louisville has never thumbed its nose at the federal government with respect to immigration. I know that's not why we're here, and I know that's not what the senator, he didn't cast any aspersions, but I just want to make that abundantly clear.
Well, thank you. Senator Nemes.
Thank you, Mr. Chairman. I'm from Bullitt County. I represent Bullitt County. It's called Bullitt for a reason. We have Knob Creek Gun Range, which is internationally known because CNN did a machine gun shoot with legal machine gun owners and said that it was a firefight in Libya. We take the Second Amendment very seriously in Bullitt County. Honestly, we do. It's not uncommon to see walking down the street someone armed. We take it very seriously, and when they come against us on the Second Amendment in laws, we say there's plenty laws on the books. You need to enforce them. Don't make another one. So, Chief, my question to you is, that is what you're trying to do, is enforce the laws on the books, give you the right to do it. Is that correct?
Yes, sir.
Thank you.
Thank you. Representative Maddox.
Thank you, Mr. Chairman. At the risk of my commentary being overly simplistic, I would just have to remark, Representative Nemes, we are state lawmakers, and our job, obviously, is to pass laws at the state level versus the federal level. We've got folks to do that, and I understand that the basis of your argument centralizes around this already being illegal at the federal level, but at the state level, it would, in fact, be a new and additional regulation on firearms, on the way that people can operate firearms, so forth, so on. And as someone who joins other members of this particular committee in being in support of the Second Amendment, I think that that should give us pause and make us really consider what it is that we are contemplating here. And it is creating a new regulation, more gun control, on our Second Amendment rights if we were to pass this into Kentucky's law, regardless of what is currently transpiring at the federal level. It has been mentioned earlier today, referring to previous court cases, things that have overturned laws at the federal level, and I understand you're saying that if that were to take place, that these laws would not be enforceable. But I would further suggest that, should a change in federal law take place outside of a court, here we are still stuck with a state law where we knowingly have passed another law that would create another new regulation on firearm owners in the Commonwealth of Kentucky. That is gun control. It would be additional and new gun control. And I see listed before me here on our committee sheet that some of the proponents who are listed are the same folks who testified in favor of red flag laws. So I think that that's also worth acknowledging, and I appreciate where you're coming from on this, and I appreciate the detailed research that you have put into this to create your argument. But just at the most simplistic, bare bones minimum level, I view this as new and additional gun control, and I have some issues with it. I'm opposed to it. Thank you.
Mr. Chairman, I want to thank Representative Maddox for her comments. I think I would say to her, I can't see her because of the camera, no disrespect, obviously. I would say that if it changes in federal law, if the statute changes, I will come and try to mirror it to federal law. So I'm not trying to create a new law. Let me just make one, I think, what is a correction. She may not. This is not new gun control. It does not put a new restriction on our people. It does not. It does not regulate what our people can do in another way. It is already illegal for a Kentuckian in Jefferson County, in Robertson County, in Pike County, in McCracken County to have one of these auto sears. It is illegal today. This doesn't change that. So to say that it puts another restriction, that is factually incorrect. It makes a restriction on federal law state law that already is there on federal law. So it does not make anything illegal, which is legal today.
Mr. Chairman, may I have a follow-up, please?
You can.
Just to clarify, it would create a new regulation in Kentucky revised statute, which is not currently there. So as state lawmakers, we would be voting to create a new regulation that does not currently exist at the state level and only exists at the federal level. Thank you.
Senator Thomas.
Thank you, Mr. Chair. Representative Nemes, all of us are very aware of the political environment that we live in today. And nothing raises more passions than when we talk about gun laws. But I believe that with regard to any law that we address, it's always better to approach it from a matter of reason as opposed to a matter of passion. Okay. I've read your bill, and it seems to be pretty straightforward. We're not talking about a 20 or 30-page bill here. It's a one-page bill. As I understand it,
it's not even 30 lines.
Right. So it's not complex. As I understand it, what we're talking about is someone who's bought what was initially a semi-automatic weapon, okay, and let's assume that they've got it registered, and now they want to convert that to a machine gun weapon that, as has been testified here today, is clearly erratic, inaccurate, and dangerous to the public. And that's what we're trying to outlaw here. A change in a weapon that was bought to something that is far more dangerous and far more inaccurate than what was purchased. Am I correct in understanding your bill?
Yes, Senator.
Okay. One point that I don't want us to overlook today that was made by you and by the chief is that in the last few years, just recently, in the last couple of years, what we've seen is a proliferation of these weapons, more and more of them being confiscated by a good police work, and thank you again, Police Chief Humphrey. So we're seeing a proliferation in the amount of these weapons, and even more worrisome, in my mind anyway, is that the owners of these guns are getting younger. You said they've gone from 29 years to 21 years now. Am I correct in your testimony, Chief? Is that you said? You said
yes,
that?
sir. That's accurate.
Okay, and that's scary to me. In the city of Louisville, of course, as you know, I'm from Lexington. To have this kind of weapon out there that's changed its nature, and we're having more of them, and we're having them in the possession of younger people. To me, it's just a common sense approach to say that, number one, we don't want to see our police officers harmed, because they're the ones on the front lines that's got to deal with this, and we don't put them in harm's way. Clearly, we don't want to put the public in harm's way as well. And to me, this has nothing to do with the Second Amendment. No one's trying to eviscerate the Second Amendment here. But every legislation that we deal with has to come from a sense of, is it good for the public? Is it going to help and benefit the public in some way? And most importantly, as lawmakers, our number one responsibility is to make sure the public is safe. Safety is our number one responsibility. We're going to make the public safe. So for those reasons, I see no problem with this legislation, Representative Nemus, and I would clearly vote for it if it came before me.
Thank you, Senator.
Representative Petrie.
Thank you, Mr. Chair. As dispassionate as I can be, we have a Class C felony for possession. I see nothing regarding mens rea of any sort. There's nothing regarding it, so I take this as a strict liability if it were in the civil side, but strict criminality in this setting. Am I reading that correctly?
It is. I think the mens rea would be built into the case, but if we need to, if it's your wish that we put intentionally possess, we can do that.
I'm just trying to make sure I address the concern. So it's strict. Then if someone handed me a device on a gun range and said, hey, this is interesting, you ought to look at it, and I stick it in my bag, I'm guilty.
Well, I don't know if you'd be prosecuted for that, but yes, if you possess an auto series, and just we need to make sure everybody, not everybody's lawyers. The mens rea just means the mental state. So you're knowingly, you're intentional. So if you intend to possess the device.
Yeah, and I understand prosecutorial discretion, and that's why I'm bringing this up, because this stands out to me when there is no mental component to the possession, and it's not a Class D, it's a Class C. Mm-hmm. That's a pretty high penalty on a very slight possession, and the mens rea might even become more important in this type of setting. Just raising it, so I know you'll think through it.
I think it's a good point.
I know you'll think through it. I'm just raising the concern. Thank you, Mr.
Representative, that's a good point. We just mirrored it after federal law. I would not be opposed to making an intentional possession. I don't have a problem with that.
And thank you.
Thank you. And this will be our last question. Co-Chairman Storm.
Mr. Chair, I have just a couple, if I may.
Please proceed.
Thank you. Lieutenant Fox, you were asked earlier by Representative Blanton to provide some statistics for the Western District of Kentucky and ATF statistics. Recall that?
Yes, sir.
And the question prompted by Senator Wheeler is because he's from Eastern Kentucky, as am I. And so I'm interested in knowing not just what's happening in Louisville, but this is a state law that you're proposing. And so I want to know what the ATF statistics are statewide. So when you get that request for Representative Blanton, don't just limit it to Louisville. I want to see the full state and ATF statistics, okay?
Yes, sir.
Because the analogy that he gave you was a 924C case, and I don't think the feds would decline to prosecute a 924C, at least not in Eastern Kentucky, okay? So that's the first request. Mm-hmm. Regarding this being called a switch, I would question how many people on the committee know even what a switch looks like. I don't. And so the reason I bring that up is because going right back with what Chairman Petrie just talked about is the knowing element here. I'm looking at paragraph 2 beginning on line 7 as well as paragraph 4 beginning on line 21. There's nothing in here about knowing possession. So if I inherit a firearm from a relative, if my grandfather passes me one down and it's been modified somehow, perhaps in Bullitt County at one of these shoots, perhaps, and I don't know that, but I inherit that, now I'm committing a crime because I'm simply possessing it, although I don't know that it's a crime. So I do appreciate what Chairman Petrie pointed out. And then the last thing I would just point out is under House Bill 5 from a few sessions ago that we've talked about, if I knowingly, or if I possess that, even if I don't knowingly possess it, but if I possess it, under House Bill 5, it's 85% because it's a firearms crime, and I get a sentence of 10 years. I'm 8.5 years in prison, and I don't even necessarily have to know that I possess something illegal. So for those reasons, I'm just pointing that out. As Chairman Petrie pointed out, I know you're going to work through those things.
Mr. Chairman, that'll be changed. We'll add the mens rea in there. I think it's implicit, but we'll make it explicit. Well, thank you for that. And just so you know, they're not hard to identify what they are. They're very easy. You can see it just by looking at it. But if you don't know, there's no way you wouldn't know the first time you pulled that trigger.
Yeah, but you're not even saying use.
I get it.
Because under federal law, there's a possession, which is 924C, and then there's also use, which is a different element. And this just talks about possession, so I don't even have to use the thing. It doesn't even have to have bullets in it.
If this bill comes to the Senate, it will come with the word intentional on it.
Thank you, sir.
Thank you.
Well, thank you very much, Representative Nemes, for a very robust discussion, and thank you to your guests as well.
Thank you, Mr. Chairman.
The second item that we're going to take up is the Department of Public Advocacy update. And if Public Advocate Preston would come forward, and Melanie Lowe, the Deputy Public Advocate, and you can introduce yourselves, and then you may proceed. And the annual report is in our folder.
Mr. Chairman, members of the committee, thank you for this opportunity and thank you for moving us up. I appreciate the opportunity. I always enjoy coming before the Judiciary. It's nice to talk to an audience that knows what we do. And so I want to take our time this morning to share some updates about our department. My name is Damon Preston. I'm the Public Advocate for Kentucky.
My name is Melanie Lowe. I'm the Deputy Public Advocate.
Today I'm going to go through real quickly. I'm going to talk about the value of Kentucky's public defense system, update on our agency personnel and some challenges we're facing. I want to present to you a brief version of the Balanced Justice Defender Reform Plan of 2026, and then at the end talk about some other challenges we face and some legislation that we expect may come up next year. As to the value of public defense, I just want to say what I hope is obvious, but it's worth reminding that public advocacy is a public service. A lot of times it's viewed only through the lens of a constitutional obligation, which it is that. You don't have a choice to not have a public defender system, but you do have a choice on how it's going to be structured. And I think Kentucky, over the last 52 years, has been a model for the nation in how it has created, developed, and supported public defense. But it's much more than a constitutional obligation. It is something that makes Kentucky safer, makes Kentucky better, and of which you can be proud. I want to just quickly, and I hadn't intended to do this or it would be on the slide, I want to quickly talk about a case that came out yesterday. I had already turned in the PowerPoint, but if you have your handy-dandy little WYMT, and those from Eastern Kentucky certainly have that. If you have that app, the top story on WYMT today is a DPA case. What happened was, a little over a week ago, a woman killed a man in Floyd County, Kentucky. She called 911, waited for the police to come. She was arrested. She was charged with murder. Police investigated the case at the time, filed charges of murder against her. The case went to district court. A preliminary hearing was held. Probable cause was found. She was kept in jail on the charge of murder. DPA got involved. DPA investigated the case, talked to their client, talked to witnesses, communicated at the preliminary hearing about the witnesses and had witnesses testify. Yesterday morning, a grand jury in Floyd County heard the evidence in the case and voted a no true bill on that case. The prosecutor was interviewed by WYMT, and the prosecutor said not a single grand juror voted in favor of indictment, because what the circumstances were is the woman had been abused her whole life by her father. When it was just her, she lived with it in terror. But she found out last week that her father had moved to the next generation and was abusing a child, her niece. And she said, this won't happen again. When the grand jury heard that story, they said this person does not need to be charged with murder and does not need to be prosecuted. And the citizens of Floyd County, through the grand jury process, dismissed it. That would not have happened without DPA's investigation, involvement, and advocacy. It would have been very easy for a defense attorney to say, this will be a good story at trial 2 years from now on this murder case. But we had the structure in place, we had an experienced lawyer, we had a good investigator, and they got the story up front, and justice was done because of DPA. Public advocacy is a public service. Society is better, freer, and safer because of public advocacy. But it goes further than just a constitutional obligation. We are protecting and improving the integrity in the justice system. We want, when a police officer, law enforcement chooses to approach somebody, pull somebody over, search somebody's house, stop somebody, question a kid in a high school, we want in the back of their minds to think, someday I'm going to have to defend this in court, because it will be better done, it will be within constitutional limits if they know that there's going to be a defense attorney on the other side that's going to make them defend this action. So we are protecting, improving integrity in the justice system. We're advancing the law through litigation. We often talk about trial cases when you hear about DPA, but DPA is an umbrella public defender organization with an appellate branch and a juvenile post-disposition branch and a post-conviction branch. They're challenging the system and advancing the law. The law of Kentucky is better because of the litigation that we do. We develop an expertise and a wealth of experience. Hopefully you've experienced this personally, and we want to be a service to you. And so we have an expertise. If you want to know how criminal justice is working in Kentucky, I can have a conversation, but even better, I can connect you with people that have a case going on right now in Webster County or Harlan County, and they can tell you how this is playing out. And hopefully you find that we provide a valuable perspective in criminal policy discussions. As I look through this room, I see many people that I've had difficult conversations with that have wanted to do something, wanted to pass a bill, and often did pass a bill, and we've been in a meeting or at this table or in the cafeteria here and said, we don't think that's the way to go. But we hope that you find that valuable, even if in the end you're able to pass a bill, hopefully with maybe some improvements that we suggest. This, just like in a courtroom, an adversarial system makes it work. I think the same thing happens in this building. If all voices are heard and a good spirited debate happens before a bill's passed, I think that's valuable. And that's part of what we do. I hope you find that we do that in a professional, polite way. If it's not, please let me know, because we always try to improve our services. And finally, constituent services is something we provide. I've talked to some of you about this. You may get phone calls from people whose son are charged or husband are charged or their house is searched, or somehow they have an interaction with the criminal justice system on the bad end of that interaction, and they're not sure what to do. Please refer them to us. Either call me directly, text me, or hopefully you've got a relationship with the local office and you can send them to the local office. We want to provide services. If they're not eligible, if they have money and they're not eligible for public defender services, we will help connect them with counsel that they can have. But that up front, I don't know what to do because my son's in jail and I've never faced this. We are happy to take that phone call to talk someone through the process and connect them with the counsel that they need to have. Here's our map. We are, of course, a statewide organization. We have 36 geographic offices throughout the state. We have 7 geographic regions that cover the state. We also have a region or a branch level equivalent to a region for our capital trial branch that handles the worst of the worst cases in the state. We just issued our annual report, and so I believe that's in your materials that were distributed. This is the numbers page from that, but there's a lot of good information. I hope you'll take advantage of an opportunity to find out about the good work that DPA is doing and all the divisions we have there. I'm not going to go through all these numbers, but suffice to say we do a lot of work. I believe we save the state considerable amount of money through our alternative sentencing plans, through our advocacy, through our post-trial relief of appeals and post-conviction that finds injustice, our Kentucky Innocence Project, and it ends up saving lots of correctional expense and saves it rightly. It's not like we hold the keys to the prison. We bring errors and injustice to the attention of courts. Courts find that to be a valid reason to reduce or eliminate a sentence, and we've saved the taxpayers millions of dollars through that.
As Damon indicated, the folks that we have working for us are some of the finest public servants in the state. And one of the great offices that we have is the Louisville office. Through legislative action, House Bill 568, as of July 1st of 2024, DPA became responsible for handling representation for all persons who were appointed a public defender in Jefferson County. Amy Hanna is the manager of the DPA trial branch there and is continuing the long legacy of excellence of that office now that it's a DPA office. And her staff and her team are doing amazing things there, just like the other offices we have throughout the state. We're happy to have them. We're happy to be a statewide system, and we appreciate the legislative action that helped us bring in that office to the excellence that DPA has too.
Another program that we have is our Alternative Sentencing Worker Program. I won't spend a lot of time on it here, but it got some attention a couple of years ago in the budget. A bill was passed last year. Senator Wheeler sponsored that made some improvements to that program, and we appreciate that support. And we are in compliance with the statute, and it has improved our education. One thing that I wanted to point out with that is that our ASW program, I believe, is more important now than it's ever been. Because if you've seen in the papers the consolidation and contraction of drug and alcohol treatment services, addiction recovery care has closed some facilities. The Isaiah House has cut their staff significantly. And so as those beds are less available, that's when you need the specialists that provide that can look among the available options and work out the funding and connect people in the criminal justice system with the treatment that they need for their mental health or their substance abuse needs. That's the specialty that our alternative sentencing workers provide, and they continue to do great work for us. Our biggest challenge in DPA, and I've said this if you've ever heard me testify, I've probably brought this up, is the fact that we have a hard time holding on to attorneys. This is a slide that shows our turnover rate for the last 2 years on attorneys. It's about 20%. I include non-attorneys just for a contrast, kind of a control group, in case there was any thought that maybe DPA is just not a good place to work. Well, our turnover rate among non-attorneys is not that high, 10, 11%. So it's half of attorneys. We have, for context, about 400 attorneys in DPA, so 20%, that's 80. We're losing about 80 attorneys a year, and in fact, that is the number there that we expect to lose this year. That's hard to replace. Later in the presentation, I'm going to talk a little bit about this year's incoming class and the work that we're doing. But losing attorneys at 20% is tough to come by because obviously you need people that are graduated from law school and are willing to work in public defense. The main reason for this, and I testified last month or 2 months ago at the budget subcommittee, so I'm not going to go in detail about this now, but the single biggest reason is our inability to have a competitive salary, not just with the private bar, but with other public service attorneys. So you can get all the benefits, all the great things about state government work, but you can make $18,000 more going across the street, working in the same courtroom, but the other side of the courtroom. And so this is our top budget request that I'll get to it shortly, but we need to pay our defenders more. This is in progress. This is not a final map. We're still working on some of the numbers, but this shows where our starting salary is compared with the starting salaries of surrounding states. It's hard enough to recruit people to come to Kentucky or to work in the difficult work of public defense. But when among the group of people that are willing to work for public defense and want to do this kind of work, and it's great work as somebody that's done 30 years, this is, I think, the best legal career you can have. But even when we have somebody that wants to do that, they can drive 10 miles across the border and make significantly more money. They can live in Kentucky and go work over there for a much higher paycheck. And it's not hypothetical. In the past year, we've lost people to Nashville. We've lost people to Southern Indiana, and we've lost people to Cincinnati, all for significant pay increases. So this is why we need to go higher. One impact of this is of the turnover is we have courtrooms without attorneys, and that's catastrophic for judges, for the service, for victims, people that need the cases to move, and we don't have an attorney to do it. But the other part is we have to divert resources to going and finding the next class. So I've included here, this is our actual schedule for recruiting that we're doing in the next month. Right now, there are people who would be here that are in, I think they're at Emory today. They're in Georgia. The blue part here. I did the red part last week. I went to IU Bloomington, Indianapolis, and up to Notre Dame. Next week, I'm going to Texas. I'm going to Baylor and UT Austin, Texas Southern, and South Texas. This has taken a lot of resources because we've got to come up with 80 lawyers. And the in-state law schools, we are getting as many as we can from them, but they can't fill the need. We have to go around the country. So let's turn to our defender reform plan for 2026. There are two parts to this plan. There's a budget part, and there's an organizational restructuring part. I'm going to go over the budget part, and then Melanie will share the organizational part with you. The budget part, there are 6 prongs. The first and most important is professional defender compensation. People who want to serve the Commonwealth through public defense should be able to be in it, to stay in it without feeling they have to go be a prosecutor, go to private practice, go work for the Cabinet for Health and Family Services, just to make a decent salary. Public defenders should make more, so that's number one. Recruiting and retention. I don't mind taking these trips, but we need to have a recruiting program rather than divert people who have other jobs to go do it. And so that's part of it. Circuit advocates, this is something that a legislator brought up a few years ago. I was skeptical at first. Now I think it is actually a really good idea. And this is the idea. I mentioned we have 36 geographic offices. You're probably aware that there are 57 judicial circuits. That means there are 21 circuits that don't have a DPA office, where DPA is driving from another circuit to go handle dockets. That means there's nobody there for emergency hearings. There's nobody there when there are witnesses to be interviewed. Our clients are often in jails there, or if they're not in jail, they can't drive over from Litchfield to Elizabethtown, just to use an example. And so this would establish 21 people, 21 experienced attorneys who would work in those counties. We would not have a brick and mortar office. We would not have a full staff, but we'd have an attorney and a non-attorney assistant that would work in those 21 circuits. And that way, when the judges in those circuits need an attorney, they know who to call. Because I've had judges that have called me and expressed frustration. I don't see why I have to call, again, to use Litchfield, E-Town, I don't see why I have to call Elizabethtown to get a lawyer in Litchfield. So that's third on our plan. Last 3 real quickly. Add a paralegal. We've never been funded for paralegals, but in times of turnover, that could provide some stability. Also, with digital discovery, a paralegal that has good skills for reviewing discovery would be a great benefit to the system. We need additional money for court plans and conflict contracts. We contract out about $8 million right now to private attorneys, and that all comes away from other parts of the agency. We'd like dedicated funding for that. And I mentioned the digital discovery. There's just a lot of technology. We can't afford to get the technology we need. Other people in the system have it. One quick example is there's a Westlaw level of with the latest Westlaw level with AI features and other things. Prosecutors have secured that. Thomson Reuters, who owns Westlaw, has come to us and said, "Don't y'all want this?" Prosecutors have it, and we've said we can't afford it. It cost us about, well, the last bid we got was about $120,000 a year extra. I don't have $120,000 to give to this, and so our defenders are at a strategic disadvantage against other people. And that's just one example. Technology is obviously advancing, and that comes with a cost. So that's our budget proposal. Now our organizational proposal.
So the last several years, DPA has worked with several legislators to introduce a piece of legislation with an eye towards some organizational needs that we have. It's a strategic plan to stabilize Kentucky's public defender system. Part of that obviously addresses the turnover issue that Damon spoke of, to retain experienced advocates and to ensure a fair and balanced justice system here in Kentucky. That's a 5-part plan contained within this, and we're hoping to get this introduced during this session upcoming. The first part of that plan is refocusing DPA representation on criminal prosecutions. That would authorize judges to appoint private counsel in certain select cases, which is a minimal part of our individual advocates' caseload, but does take a lot of time to be available for those particular courts. And specifically, we're talking about adult family court, civil contempt actions, involuntary hospitalizations under KRS Chapter 202A, and Tim's Law cases, court-ordered assisted outpatient treatment, as well as Casey's Law, which are involuntary treatment for substance use disorder. If we were no longer handling those cases, judges would have the opportunity to appoint private counsel to handle those, and it would open up and refocus our advocates on taking care of criminal prosecutions, which obviously is the core function under Chapter 31. The second part is to define circuit advocates. Damon has mentioned that circuit advocate plan that was proposed by a legislator a couple of sessions ago. Those attorneys will be responsible for ensuring that there is adequate legal services in every judicial circuit throughout the Commonwealth. The third part is establishing a system of compensation that allows flexibility so that the public advocate has the ability to react to situational wage discrepancy between a public advocate and the prosecutor system, to have the ability to set that defender's pay outside of the personnel cabinet guidelines would allow us the flexibility to retain people who are valued, who are experienced, who we have trained, and who are doing great work for the citizens of the Commonwealth as public advocates. The fourth part is to clarify an ethical issue, a prohibition of acceptance of private fees by defenders. The conflict attorneys who handle cases for us are not currently, or it's not clear that they're permitted to handle matters for DPA clients that an advocate wouldn't handle. For example, they may be handling a criminal case. Perhaps they want to hire that attorney because he's done a great job for them. They want to hire that attorney to handle their divorce or a child custody issue and pay them to do that. There's question about whether or not that's allowable under the ethical rules, and that would provide some assistance in clarifying that issue so that we can continue to get good conflict attorneys to handle the conflict matters for DPA. The fifth part is a language cleanup. There's some non-policy changes, semantic changes to reflect current practices and to update language that ensures that there's clarity and that the current statute meets the demands of the Commonwealth's justice system currently.
All right, I'll end with a couple of other challenges that we face. First, on criminal law legislation. There are a couple bills today dealing with criminal law. If you are crafting bills, we are ready and willing to collaborate on criminal justice policy. As I said earlier, we may not start on the same page, we may not end on the same page, but I think we're working together and having a good conversation, we can improve whatever legislation that you're working with. And so we stand ready for that. So if you are working on bills, please contact me, and happy to come meet with you and give you our perspective. And I'll say generally, we don't miss criminal law legislation. So if this is a good time to have a conversation, so we don't end up with an uncomfortable conversation in February when we say, we really don't. We've got feedback that would be helpful on this, and that's a difficult time when the time pressure. So, if in this interim you'd like to talk, any of you, we'd be happy to talk with you. And I would say, I used to. In fact, this is, I think, the first time since I've been public advocate in 2017 that I haven't done this testimony without a scorecard. If you've seen, I keep a scorecard of how many bills are passed that expand criminal justice by either raising penalties or expanding elements or creating new crimes. I have that scorecard, but I'm taking it out today. But suffice it to say that if I showed it, this is not really an era where criminal justice reform is making any progress in this chamber, and I'm aware of that. So what I wanted to say today is, if you strengthen public defense, you are engaging in criminal justice reform without changing the law. You don't have to vote for any reduction of sentence. You don't have to vote to eliminate any crime. But strengthening public defense assures that the law works the way you want it to work. We are working in courtrooms, and when our defenders have the time, have the experience and the time to handle cases competently, the law works the way you intend it to. And so this is one vote. As the budget's coming and the organizational bill that we'll propose, voting to strengthen public defense is a way to improve the criminal justice system, even without voting for what could be considered a reform bill. Another bill that's probably coming is video conferencing or video courts. And so I've included here, this is a criminal rule out of Wisconsin. I intentionally made it small because the intent's not to read it, it's just to show it exists. We've been doing a substantial amount of research about virtual courts around the country. Most states have either passed a statute or their Supreme Court has passed a criminal rule or a civil rule, if necessary, to deal with virtual courts. I think Kentucky needs that. There have been some proposals. We stand ready to participate in that, whether it's done here through the legislative process or where are we now, across the street or somewhere else in the state while they're renovating the Supreme Court, wherever the Supreme Court is these days. If it's done through the rule process, we'll participate with that as well. But I included the language of the Wisconsin rule here because it's something that I think everybody here would agree with. It's the intent that video conferencing technology be available for use in circuit courts to the greatest extent possible, consistent with limitations of technology, the rights of litigants and participants, and the need to preserve the decorum and fairness of court proceedings. That's our goal. But we need to figure out how do we get there. We're ready to participate in that, and we look forward to those conversations. I mentioned this last year, so I'm just going to quickly say it again. I don't think there'll be legislation about this. I continue to work with the Justice Cabinet. But this falls in the public defense is just a hard job these days. We have attorneys that are going to prisons to see clients, as they are ethically required to do, and they are being invasively searched just to do their job. And I bring this up partly because it's happened just in the last week. We had a female employee that visited a DOC facility. She walked in the door with a male who was either an attorney or a counselor or someone else who was going to see a client. The male's in front of her. The security guard comes, does the wand, and says, "You're free to go. You go on to the conference room." She walks right behind him and says, "Oh, you need to go through the body scanner." DOC policy is that body scans, because they're invasive, because they basically show your naked body, they are supposed to be same gender. There was no effort for same gender. The same person that told her she had to go through the body scanner went and reviewed the scan as she was going through, and then she went to the room and sat right beside the man who was seeing his client while she was seeing her client. I'm not here to debate prison security. I get the concerns. but what our people are facing in both disparate treatment and just invasion for them to do their professional job. Our people are professional. They have ethical duties. They are bound by the law. They need to be held accountable if they break the rules. But this is, I mentioned this today just to say, it's a tough job. We are asking a lot of our public defenders. We have had people that have left us. This contributes to turnover. I'm not going to say it's a lot, but we have had people who left that in their exit interview said, I was tired of being harassed every time I go to visit a client. And so I'm working with Secretary Jackson. These are DOC facilities I'm talking about here. And so we'll try to make progress, but I want to speak up for that, as this is an issue that we're facing. But while we're facing that, we are making a difference. I talked about the Floyd County case. All of these are pictures of our employees with their clients after they've been able to make a difference. It is an often thankless job. There are many jobs in government that are thankless, and I would say you all sit in them. Being a state legislator is a thankless job. You hear the bad, and it's rare that people come to you and probably just pat you on the back and say, I appreciate what you do. I'll say that now. I appreciate what you do, because you're all taking time away from family and your other jobs to come and make a difference for Kentucky. I appreciate that you do it, and I appreciate the people that we have that are doing it every day around the state. And I want to just end by celebrating our new class. I talked about our recruiting, and our recruiting gets us what we need right now. We need more money. We need more money to retain people. We need more money to accomplish the recruiting. But this is our incoming class. They all started on August 18th, so they've been with us almost exactly a month at this point. If you look through the schools, I'll count them for you. There's 45 there. 25 of them come from either Louisville, UK, or Chase. The other 20, some are nearby, Cincinnati, Appalachian, Southern Illinois. But then you got a Pepperdine, you got a UC Irvine, you got people that have come long distances because they believe that justice can be done here through being a public defender in Kentucky. The ones who didn't come from Kentucky, almost all of them had no ties to Kentucky. But we told them that Kentucky's a beautiful state, a great place to live, and it's a place where justice can be done and they can make a difference. I started with the Floyd County story, so let me give you just a quick coda on that. If you go to WYMT's website, or you go look on their app, they've got a picture to go with their story, and there's two people in that picture. One is the woman who was charged, who now has a life to lead without abuse because she was set free by the grand jury. The other person is our lawyer sitting beside her at the preliminary hearing. That lawyer, and I won't give her name because I haven't asked her for permission, but that lawyer resigned from DPA in 2021 to go work for a nonprofit for a little more money. In 2022, you passed a budget that gave us money for higher salaries for public defenders. And in May of 2022, that lawyer, after being gone for only 5 months, came back to DPA, and she's still with us. The murder case was dismissed because of the work of a lawyer that we wouldn't have if you hadn't passed a budget in 2022 giving us additional money. This class is going to be around or not based on the support that I give them as an administrator and that you give them as a legislature. I'm asking you to support public defense in our requests, but also as an agency, get to know your local people and recognize the public value of public advocacy. Mr. Chairman, I appreciate the time, and I'm welcome to take any questions.
Thank you so much, Advocate Preston, and I don't think we have any questions. We're going to defer those to the end of the meeting if any member does, but we appreciate your time and appreciate the compliments. We take all those that we can get up here.
Thank you.
Thank you. The next item is an act relating to boating under the influence, Representative Fleming, and I know that you have some guests. And we'll limit the presentation to 10 minutes and any questions that members may have.
Thank
Please
you very
proceed.
much, Mr. Chairman, I appreciate the opportunity. I'm Ken Fleming. I represent part of Jefferson and Oldham County. And we'll go ahead and have my guests introduce themselves as well.
I'm Heather Yelton. Sorry, I'm Heather Yelton.
Hi, I'm Aaron Yelton.
And also today, Mr. Chairman, we have individuals, the Colonel and the Commissioner from Fish and Wildlife to answer any questions that might come up. What is in your packet is a proposed language to look at boating under the influence. When Heather mentioned, and I talked to her some time ago, in regards to the tragic accident of her son, Keegan Peterson, it became pretty obvious that we need to look at mirroring what goes on in terms of DUIs and need to apply it to boating under the influence. And just like we go down the road, we need to stay in our lanes, be conscious of what we do and so forth. Well, boating is a little different. There's no lanes, but we still need to act and conduct ourselves responsible and accountable in terms of operating a vehicle, whether it's, not a vehicle, but a motorboat, whether it's a Sea-Doo or even a canoe or even a motorized boat. So what this basically proposed bill will do is look at and give the Fish and Wildlife officers the ability to provide or have a search warrant for a blood test. And we won't go into particular details of what occurred to Keegan and what I know of him. I wish I would have know him since he's a big soccer advocate like I was, and for many years. It's a tragic that something like that happened, and then we have to look back and say, well, we should have changed something. We should have did something to be more proactive. I'm going to let Heather sort of give you her story. She'll come back to me, and Aaron will have a comment, come back to me. I'm going to add one more thing to this bill that's not in here that I think it's really going to be a game changer. And then, like I said, the Commissioner and the Colonel can answer any questions you might have from a case law or any type of issues that you might have in terms of boating.
Thanks. Good afternoon. Again, my name is Heather Yelton, and I'm Keegan Peterson's mom. I'm here today to speak on behalf of my son and all families that have experienced tragedy on the water. On July 21st, my 12-year-old son, Keegan, was tragically killed in a jet ski accident on Nolan Lake. He was there with his friends and their family. I got a call that Sunday afternoon, about an hour after the incident, that Keegan was hit by a jet ski and was being airlifted to Norton Children's Hospital in Louisville. The days that followed were a blur of grief, shock, and confusion. We got a very high-level story about what happened. The mom was driving the boat, pulling Keegan and their son on the tube, and the dad was riding a jet ski and somehow hit Keegan and the tube. And as the facts of the case came to light, that confusion turned to a profound sense of injustice. The first responding officers did not arrive on the scene until over an hour after the incident. They took statements and conducted a basic field sobriety test, which the adult operators passed, but no blood work was ever done. Due to this gap in our current laws, my family will never know if drugs and alcohol were a factor in my son's death. When a boating accident is serious enough to cause a critical injury or fatality, the investigation should be as thorough as possible, and it doesn't feel like that is happening right now. That's why I'm here today, and I ask for your support in helping pass Keegan's bill. This bill making it mandatory for adult operators to undergo a blood test when there's been a serious accident that results in critical injury or death. This is not about assigning blame after a tragedy has occurred, but is about ensuring that law enforcement has the necessary tools to conduct an investigation from the start. I know this seems like it might be a small change and something that was just overlooked, but to our family, this would mean everything. This would mean that my son's legacy is not just about his tragic death, but a change that protects other victims and provides families the answers they deserve. Thank you for your time and listening to my story.
Hi, I'm Aaron Yelton. I am Keegan Peterson's stepfather, and I'm here today to speak on behalf of Keegan's father, Chris Peterson, who was unable to be here today, but did give a statement and ask me to share his words. My son, Keegan Peterson, was a 12-year-old boy who was just getting started. He brought so much energy and enthusiasm to everything he did. He was the person in our household that brought us all together. He was also the one who created a fun, chaotic environment that is so much missed today. Our house is quiet now. All we have are memories, pictures, and stories to share. All we want is to give him a hug, tell him how proud we are of him, and how much we love him. We will never have that opportunity again. Keegan did not have family with him on Nolan Lake that day. Trust was given to other adults to keep him safe. While Keegan was riding on a tube behind his speedboat, he was hit by a jet ski while still on the tube. He suffered a large laceration to his head and was immediately thrown off the tube and into the water, where he suffered a drowning event. When you go for a long period of time without oxygen to your brain, it can cause a lot of problems to your brain and other major organs. The drowning event may ultimately have been the cause of death. How can this event described not be deemed serious enough to conduct a thorough investigation? How? Explain that to me. We have so many questions and not enough evidence or answers to find peace. The hour and a half that it took the first responders to arrive at the scene is unacceptable. We know that at least one family member involved had already gone back home, showered, and changed clothes before returning to speak with the state officials. The fact that Kentucky Fish and Wildlife made the decision to rule out foul play without doing proper tests on those involved is unacceptable. If this happened on land, the investigation would have been handled much differently. Why are we not taking serious injuries or death on our waterways more serious? It doesn't make sense. I appreciate the opportunity to be a part of presenting this bill to you. The passing of Keegan's Law would be an amazing change that would protect other victims and hopefully give families information to questions that they so much deserve. Thank you so much for your consideration, and please don't forget to go home today and tell those that are most important to you how much you love them. You never know what tomorrow will bring. Thank you.
Thank you. Chairman, ladies and gentlemen of the committee, I have talked to the Fish and Wildlife, both the commissioner and the colonel, and what we discovered is that Fish and Wildlife did, and not to contradict what he said, but they did respond properly. They responded, in fact, within 8 to 10 minutes when they received the call. And what we found out and what we discovered is that the Fish and Wildlife has a contract to route calls. They basically dispatch with 911 officials, with the state police. And so if that were a call, and I'm going to add this language to the bill. So what I would like to do is that when a call goes into 911, that dispatcher will not only dispatch the local police, but also the state police, which the Fish and Wildlife would be dispatched immediately. So instead of an hour and 20 minutes, that would have been, if they got in the phone call, they would have been there 8 to 10 minutes after the incident. And that's a significant game changer in order to do that. So the Fish and Wildlife, officers, my understanding, did what they could within the law in order to address the situation as much as possible. And they do a lot of good, as y'all know, within our state, and we're very, very proud of what they do and so forth. So with that, it's basically two things. As I mentioned, as far as changing or looking at routing the 911 calls to the state police, but also give the law enforcement officers the ability to seek a warrant. That's what it is, Mr. Chairman.
Thank you, Representative. Ms. Yelton, you certainly have our sympathy, and to the family, we're very sorry for your loss. Thank you for your presentation. The final presentation that we will have is an act relating to grooming. Representative Mary Ann Proctor, and she has Lewis Kelly, who's the Commonwealth attorney for the 54th Circuit, with her. So you all may introduce yourselves and proceed.
Thank you, Mr. Chair.
And we'll limit the time to 10 minutes, okay?
Yes.
Thank you.
I'm Mary Ann Proctor. I represent the 60th.
Good afternoon. My name is Lewis Kelly. I'm the Commonwealth's attorney for Kentucky's 54th Judicial Circuit, which is comprised of Boone and Gallatin counties.
So I want to thank you for the opportunity to present to the committee today this bill on grooming. It was brought to me by constituents, the Boone County Sheriff's Office, the Commonwealth Attorney, and our county attorney. This has become an increasing problem. What this bill seeks to do is define what a groomer is. There currently is no statute that defines grooming or has any criminalization. So we're looking to do that. Basically what it is defining what a groomer is. It's an adult in a position of authority or special trust that engages in behaviors with a minor to prepare them for future sexual conduct. For further explanation of the bill and to answer some of the questions you may have, I'm going to defer to Lewis Kelly.
Thank you, Representative Proctor, Mr. Chairman, and committee members. The need for this bill, I go back and I reference something the General Assembly did back in 2019 when I first became Commonwealth's attorney. They enacted a strangulation law. And what was interesting about that is if you prosecute rape cases, you will find that the overwhelming majority of them, the history of that relationship, months or years before, there was a strangulation incident. There's not really a lot we could do in terms of prosecuting those people, because at the time the most we could prosecute was an assault in the 4th degree, which was a Class A misdemeanor. And it really didn't have an impact on stopping the escalation of the violence. Since 2019, you passed it. Now that's a Class C felony for strangulation in the 1st degree, and it's a Class D felony for strangulation in the 2nd degree. I can tell you since that law went into effect, my office has prosecuted just in the 54th probably close to 100 strangulation cases. And that number probably goes closer to 1,000 if you go across the Commonwealth, which is to say I am fairly certain that because we had this new and stricter law to catch this intervening act, I believe we've prevented rapes from occurring in the Commonwealth of Kentucky. Likewise, here in the Commonwealth, we have laws that can penalize and we can prosecute people who do engage, adults who engage in sexual acts with minors. We can do it if they go and explicitly illicit sex with minors. We can do that. But what we see in all of those cases is there is a long and protracted pattern of highly inappropriate and very suggestive behavior. And in fact, I think Representative Proctor was sponsored by this because we had such an incident in Boone County at a middle school that my daughter attended. But there was a big gap. There wasn't something there to enforce that. So what this would do would be to allow us to identify and to prosecute and stop this in its tracks before it crosses the line into actually enticing or eliciting sex or, God forbid, an actual sexual conduct. I'm sure there'll be questions about, things that are innocent and how do you tell. This bill does address that. We have specific carve-outs for people that might have to have communication with young people. We also have included an intent provision that that was spoke about in some of these other bills. It's clear we're going to have to prove that this was not some innocent or good faith discussion. I can tell you, at least in my law enforcement in my jurisdiction and my office, we have no desire to prosecute people who are otherwise engaging in innocent, even if misguided. What we want, and in this case that prompted this, there was no innocent reason why this person was engaging in these discussions, but he never crossed the line. Not yet. They were fortunate enough to find it and stop it, and he's no longer teaching. But he really faced no real criminal penalties for this. So that's why we're doing it. So that's why I would respectfully request when this bill is filed in the session that this bill be heard in both the House and Senate Judiciary committees and be reported favorably. Thank you. And we'd be happy to answer any questions.
Thank you. And there is some discussion. Representative Roberts.
Representative Proctor, Commonwealth Attorney Kelly, thank you both for presenting this bill. I think protecting our children is one of the highest duties that we have as a legislature, and you're doing that with this bill. I do have one question, though. Right now, Kentucky is one of only 9 states that makes it to where the victim of the offender must actually be 18 years old. In 41 states, all that is required is that the offender believes the person to be a minor, whatever the age is. In this case, this is a 14 years old for the grooming bill. I was just wondering if you guys would be open to including language and fixing that provision that we have right now, because there are people who have gotten away with it even though they genuinely believed that they were enticing a minor, whether that be in the grooming context or in the context of what's already illegal. So I just wanted to get your thoughts on that.
I can tell you, I would certainly be open to things of that nature.
Thank you.
Thank you, Representative Roberts.
Thank you. Representative Burke. Yeah. Representative Burke.
Thank you, Mr. Chairman, and thank you, Representative Proctor, for bringing this bill. I certainly applaud the intent and agree that it's needed. We need to do everything we can to ensure that young people are safe when they're at school, when they're at home, when they're in the community, and I do think this bill is going in the right direction. My question is sort of in the same vein as Representative Roberts, because it strikes me that the draft currently is a little bit narrow and could be wider as far as who is a potential victim and also who is a potential perpetrator. So I'm noticing that you have to be 18 to be culpable. And I would think that a 17-year-old or 17-and-a-half-year-old who's engaging in this type of conduct with a 10-year-old is doing something really wrong. And perhaps by having such a narrow threshold, we're going to miss potentially very damaging conduct. So that's something I would like to talk with you about and encourage us to find a way to ensure that we don't leave out perpetrators who should be captured here. Then I'm a little concerned about Section 1B2 being too wide. And the specific language here is developing an intimate or secretive relationship with a minor. All the other definitions tend to be fairly clear because of the definitional section. But my worry is that someone in a position of trust, like a big brother or a big sister, or a CASA worker who's volunteering for the court system to ensure that young people are able to report abuse, that they may be sort of tiptoeing into this zone unintentionally. And I just would hate to see someone who's trying to do the right thing be prosecuted. I accept your assurance that in Boone and Gallatin County that would never happen, but I would hate to see it happen anywhere.
And Representative Proctor, if I may. I would say that, and I understand, and we have had significant talks about trying to, on the one hand, be broad enough that we can cover things that aren't anticipated. As you know, with the change in technology, we can barely comprehend what even the threats the future will bring just a few months. So we've tried to do that, but also not be too broad. I will say this particular bill, Section 3D, which carves out some of the specific exemptions, mentions communicating with a minor to determine if the minor is dependent, neglected, or abused. So there are things when you're clearly doing something, and because maybe you think there is an abusive parent, that would protect that. Again, that's also why we had the mens rea component, which quite frankly makes my job harder. But as I told Representative Proctor, I'm willing to take that burden and make that hard. It should be hard to do this if they are not explicitly doing it, but in the cases we found, these things are so clearly highly inappropriate that I don't feel that is a big risk, but I do think that Section D really addresses that question. As far as the other issue with 17, I would note that would have to be part of the Juvenile Code of Justice because that would be doing juvenile, so that might not be germane for this particular bill, which is dealing more with adults, and I would think would want to focus more with the county attorneys because they prosecute juvenile cases unless they are transferred up.
Thank you.
You're very welcome.
Thank you. Is there any other member with anything they want to? Senator Carroll.
Thank you, Mr. Chairman. And I know in my district there was a case related to this, and I think the offender was charged with harassment in the end. So I think obviously there is a need for this. Did you all have any discussion about the possibility of maybe more specifically defining the conduct, as in certain terms or language or request to meet, or just being more specific that might better define what the course of conduct includes? You can make a lot of assumptions that's what it was about, but to make a case stronger, I would think having specific terms, discussions about sexual preference, whatever the case might be, that is related, specifically related to the ultimate goal of the offender. If that makes sense.
It does. And I would say I think we're at least in my position, and at least in talking, I don't want to speak for Representative Proctor, but they've always shown an interest. If we can make this bill better, we're certainly open to that. But one thing I will note is sometimes when you put too explicitly what's prohibited, then that gives them the line that they know how to walk right up to. And again, what we tried to balance is not having something that is so wide that people don't know what's illegal or it could be caught up unknowingly, but also having enough space to tackle unique challenges, not only that we exist now, but exist in the future. But certainly if we have looked, I know Representative Proctor has heavily researched what other states are doing, including Ohio and I think Texas maybe.
Texas, Minnesota, Georgia.
And this language, is consistent with that. So we at least know in Ohio, which is close to my jurisdiction, they're doing something and it's not there. But certainly, if we have some language that makes some sense, I think we would be open to that.
I think using the term including but not limited to, that wouldn't pin you into a corner, but kind of set a tone for what you're looking at. And,
I think that's an excellent point. I think we'd be willing to consider that.
Thank you very much, and if there isn't any more discussion, then we will stand adjourned. The next meeting is Thursday, October the 16th at 11 a.m. So, thank you very much. Thank you, Representative Proctor.